Okay. Welcome to Parent Conversations. Happy last day of January. Yay, I'm so excited to see January go. Wanted to just welcome everybody today. We have a couple of guests with us. We have Valeria Jimenez from I'm going to get this right. I'm going to actually read it so I get it right. The Office of Fairness and Accountability with the Utah Courts. And we have Bryan Galloway, Judge Galloway from is it the First District Court of Cache County?
First District Court, correct.
First District Court. Okay, Cache County is the First District Court. We want to say thank you to the Bear River Health Department and the Central Utah Public Health Department and the Davis County Health Department. They have provided grants that make parent conversations possible. Thank you, thank you, thank you. We couldn't do this without you. We're going to go ahead and turn the time over to Valeria. And if you have questions, as always, you feel free to raise your hand. You can put it in the chat. I will be moderating. My name is Megan, and I'm the Assistant Director with My Discovery Destination and the Assistant of the Discovery Family Coalition. So go ahead, Valeria, take it over, and I will just kind of interject as it seems fit to do so.
Perfect. Awesome. Thanks so much, Megan. So hi, everyone. Thank you for having the Utah State Courts today. Judge Galloway and I are very excited to join you all. Thanks to Megan and Shirley for putting this together, and thanks to all of you for being here today and tuning in. My name is Valeria Jimenez, and I'm the Public Outreach Coordinator for the Utah State Courts. And as Megan mentioned, I work in the Office of Fairness and Accountability. So it's a new office that was established about a year ago at the courts. And through my role, I'm responsible for public outreach and education of court programs to the public, and also working with our judges, court staff, community leaders, and Utah community-based organizations to help improve the awareness of programs, especially among historically marginalized communities. We also want to get our youth excited about the judiciary. We've been participating in discussions like these, doing workshops on the legal profession by partnering with local after-school youth programs and bringing judges into the classrooms to talk about their role and responsibilities with high school students. We've been working with the Latinos in Action and AVID programs to have judges as guest speakers and encourage students to consider a career in the law and help them understand how the Utah courts system works. If you have any questions regarding these visits, court programs, or want to connect, please feel free to reach out to me. I'll put my contact information in the chat. And I'm very excited to introduce Judge Bryan Galloway. Judge Bryan Galloway was appointed to the First District Juvenile Court in 2020 by Governor Herbert. He serves Cache, Box Elder, and Rich counties. Judge Galloway received a Bachelor of Arts degree from Utah State University and then graduated from the University of Nebraska College of Law in 1998. Following law school, Judge Galloway returned to Utah and began a law practice that primarily focused on criminal and parental defense. Eventually, Judge Galloway evolved into a practice of indigent defense, appearing as a public defender in the juvenile justice and district courts of Cache County. As public defender, Judge Galloway worked extensively with the drug and mental health courts of the First District. He served over 13 years on the First District Mental Health Court Committee. Judge Galloway will be speaking with you all today about the role of the judiciary, who the people are in juvenile court, the difference between juvenile court and adult court, and just in general, what parents should know about the courts as it relates to their kids. Feel free to ask questions, and Judge Galloway, I'll turn the time over to you.
No, thank you, Valeria. I am excited to be here today. I wish I got an opportunity to do more of these kind of outreach things. In saying that, Valeria is probably going to line me up with a bunch of stuff in the future. And I think that you got a little bit of an introduction to who I am. I think it's a little bit important for you all to understand kind of who's giving the presentation today. I've been on the bench for 2 years. Before that, I primarily was a public defender, and so I did a lot of criminal defense. I worked in the juvenile courts a substantial amount, mainly defending the parents that get involved in the juvenile court. I did defend the kids some, but that didn't fall into my contract quite as much. Maybe probably the piece of information about me that may be most important is that I'm a father to 3 teenagers. And so even though I may appear to have some of the answers as it relates to my career and profession as a judge and an attorney, I can tell you that sometimes all answers go out the window when you're actually putting things into place, dealing with kids. But anyway, I do have 3 teenagers. I have a daughter and 2 sons. They all go to high school here in the Valley. Ironically, different high schools. They don't all go to the same high school, which makes it interesting at dinner time. And I would like to just thank y'all for extending the invitation to speak here today. Now, I admit, I'm coming into this not really knowing where all of your interests lie and where your questions are. But I'm just going to kind of initiate the conversation towards explaining the juvenile court, kind of trying to demystify what the juvenile court is. And then please feel free to ask any questions, or you can put the questions into the chat feature if you feel free. And I'll be happy to do my best to provide an answer. I'm not going to tell you that I know everything, but I can at least kind of wade my way through it. Okay, juvenile court. And I want to do this in a way, one of my things, I constantly beating this drum, but we have a way in the court system of making things more intimidating and complicated than I believe they really need to be. And I don't know, sometimes I feel like we kind of put ourselves on a pedestal with regards to the language we use, how we approach kind of this air of mystery and superiority. And I don't want it to be that way at all. And so I try to really use plain language in discussing the courts. And I try to use plain language in my court, in talking to the kids and the parents. And so I'm going to try to avoid the trap of falling into a lot of legalese as I give you the information here today. But if anything comes up that you just don't understand what in the heck I'm talking about, like I said, ask a question. All right, juvenile courts essentially break down into 2 areas. And the 2 areas are kids getting in trouble and parents essentially kind of getting in trouble, but not parenting correctly or enough. And that falls into a neglect or abuse is generally what we look at there with regards to the parent aspect of things. In the court, it's really kind of 2 separate types of hearings that we have and processes that we do with regards to those 2 separate type of cases that come in. First of all, the kids. Let's talk about the kids and when they get in trouble. Kids can find themselves in the juvenile court for breaking the same laws that adults do. We look at the same code, we look at the same statutes, we look at the same laws. They will generally apply to kids the same way they will adults. There are some exceptions where in which a kid can get in trouble for things that an adult can't. For instance, drinking, MIP alcohol, tobacco, curfew. Some things you get in trouble for just for being a kid and doing the same things that adults could do. And all of those things generally find themselves coming in under the purview of the juvenile court. Now, what happens? What brings a kid into the juvenile court? A lot of times it's the same thing that brings an adult into the district court, okay? Now, I should back up a little bit. Even though it sounds like these are criminal proceedings and they have a lot of the same aspects of an adult criminal proceeding in the district court, we really look at it differently in the juvenile court when a kid gets in trouble versus when an adult gets charged. You're going to hear a lot of language about best interest of the child and what would be a benefit to the child and what can we do to help the child. And that includes the kids that, not only the kids that are, living in homes that are neglect or abuse homes, but also the kids that come into the court for committing a crime, essentially. We're still looking at what we can do to provide this kid with the best opportunity to put himself or herself in the best position to be successful in life. And that's how we approach things, okay? Now, we do have to balance things somewhat with community safety. And we have to balance things with regards to making reparations for the things that kids do wrong. And so all of those things come into our decision making, but generally speaking, the best interest of the kid is always going to be at the forefront of everything we do in the juvenile court. All right, a kid gets in trouble, you know, whatever it may be, gets in a fight, shoplifts, drugs, you know, use your imagination. I know the kids do, so they find all kinds of ways to get into court. It's usually just initiated by standard law enforcement. Sometimes, a lot of times the schools reach out and say, hey, we have a kid that's not behaving well, or he gets in trouble at school. But they essentially get, law enforcement gets involved, and eventually an investigation takes place and a referral comes to the court, okay? Now, under the juvenile court, a couple of things happen. Number one, the juvenile court is fortunate enough that we have an entire probation system underneath the court that works for the court. So a referral comes in, and usually the first thing that happens is a kid is referred to probation. Probation reaches out to the kid or the family and says, hey, you know, we got this thing, come in and talk to us. We want to talk to you, get to know you, figure out what's going on. And so as parents, if you ever see one of those come in, that's what's happening. It's essentially probation sending a letter out saying that, oh, you better come in and talk to us. At the same time, there may be a prosecutor involved. Now, the prosecutor is who formally would bring charges to the court if a crime has been committed. And so the prosecutor may be somewhat involved, probation is somewhat involved, and they try to get the parents and the kid involved. So all of them come in, they have kind of an intake, they call it. They get to know the kid, they discuss with the kid what's going on, with the parents, how things are at home. They try to just get to know them a little bit and find out more about the incident that occurred that led to this referral coming into the court. Now, here's one of the places where things are different in juvenile court versus district court versus the adult court. And I should say a couple of things, but I'll start with this. Kids get quite a few bites at the apple before they have to actually come and see the judge, unless the kid's involved in felonies, violence, more aggravated things. If it's the run-of-the-mill, you know, retail theft, some alcohol a lot of times, even marijuana, misdemeanor offenses that are non-violent, generally the kid and the family have a chance to go into the system, meet with probation, and do what we call a non-judicial. And that essentially means that the kid can enter into a program, basically a contract, that, okay, I'm going to work with probation, I'm going to do the probation program. They're going to see where some of the risks are for the kid, see how they can address some of those risks, put the kid on kind of better footing. The kid completes the program and the case goes away. And so kids get quite a few chances to come into the court system without ever actually having to go in front of a judge and have a record as it relates to their delinquency or criminal, I'll say criminal, but it's actually delinquency in juvenile court. Now, let's say, so you get the referral, you come in, you meet with probation, you can do the non-judicial, you can do that about 5 times, to be honest. You get quite a few bites at that. And after that amount of times, if you just keep coming back, eventually the law says, okay, you're gonna go see the judge. We've tried the non-judicials, it didn't work. You're now gonna go see the judge. So you can end up in front of the judge by continually getting in misdemeanor charges or committing a felony, can get you in front of the judge. All right, I know I'm gonna bounce around a little bit, but I try to get some information out. Now, a kid can, upon being accused of a criminal act, can be placed in a detention center, okay? If it's a violent act, if it's an act that, you know, qualifies for detention insofar as the public appears to be at risk, instead of going through all of this process that it comes into the court through intake and probation, law enforcement can pick the kid up, take them down to the detention center, put them through intake of the detention, and there they are. The judge always, by law, within 24 hours, has to review whether that kid is in detention legally or not. So if a kid gets thrown in detention, I'm going to get an email or a text at any point, usually in the middle of the night, and they're going to say, hey, go to your computer and look at this and see if this kid should be in detention or not. So that gets run by the judge. Usually, at least in my jurisdiction, they're pretty careful with regards to putting kids in detention. They don't like to do that if they can avoid it. And so normally I'll say, yeah, let's keep him in detention, get things cooled down until we at least get a plan in place where hopefully we can release this kid. At that point, if a kid is in detention, essentially the first day I get into work, we get him into court, get him or her into court. We sit down, we have probation there, we have the parents there, we have the prosecutor there, we have a defense attorney there. And at that point, we have to make a quick determination. Everybody gives their argument, and the judge has to make a quick determination. Hey, are we going to keep this kid in detention, or can we safely release the kid from being in detention? It just depends. A lot of times I will release them if I feel they can be safely released back to the parents. All right, that brings me to when we get to court, okay? When you actually walk in the door to court, either by way of, the prosecutor filed a case in which the kid failed his non-judicials, or it's a felony, you will walk into court as a parent and you will be like, who are all these people? Because in juvenile court, there's a lot of people that attend the hearings. And I'm not going to get too far down the rabbit hole, but I do want to let you know, number one, don't be surprised when there's way more people there than you expected. And I'm not talking people from the public. It's not people from the public. It's actually people within the juvenile justice system that are there that are essentially going to become a part of this kid's case going forward, okay? And so first thing you'll notice is you'll come to court, you'll be in the hall, and there'll be a bailiff. Just a standard court bailiff. So the bailiff will have you come into court, will kind of tell you, okay, parent sit here, kid sits here. Now, what we do is as soon as a case is entered into our court system, we appoint an attorney to represent the kid. And this happens quickly, and many times people actually get into the court with the kid before the attorney even having the opportunity to really sit down with the kid and parents to go through the case. And so don't be surprised if you have an attorney there, the judge says, okay, you've got Mr. Perry here to represent you, he's your attorney. And we do that because we believe, and by law, that a kid should have representation every time they go in front of the court. Courts are confusing. It's confusing for me, honestly, sometimes. And they need to have somebody there to stand up and say, hey, slow down, let's take a deep breath here. So there'll be an attorney there to represent the kid. There will be a prosecutor there. Prosecutor is the attorney that brought the charges. Prosecutor works usually for the county or the state and says, we believe this kid committed a crime, committed an act, and we are asking you, judge, to prosecute the case, okay? You will also have a representative from probation. A probation representative will probably be somebody that has already reached out to the family prior to getting into court. And so the family may feel a little bit of a comfort with that person because they've at least had some communication with that probation person prior to court. There will also be my clerk. My clerk's here to basically make my life so I can do the stuff I do in court. They do great, kind of coordinating everything. You can also, if the kid is in detention, have actually a member of the staff from the detention center. You can have a representative from Juvenile Justice Services, okay? Now, I know that I'm speaking a number of different agencies here and that it just becomes letters in everybody's head. But in the juvenile system, with regards to delinquency, just know you have the court, under the court is probation, and separately is Juvenile Justice Services, okay? They work under the Utah Human Services Department, I believe. So you will have a number of different state agencies there. And each one of them, including the parents, the kid, the attorneys, probation and juvenile justice services, will have an opportunity to give their thoughts with regards to what should happen at this point, okay? And that will include hearings where in which a kid is still in detention and hearings that are just coming to court or in which the kid is no longer in detention. I gotta catch my breath. All right, at this point, it feels like a criminal case in district court with a lot more people involved. And that's really kind of what it is, okay? A couple of things to know about juvenile court. We don't have juries. And so unlike district court where an adult can go say, hey, I want a jury, you know, fill the box, bring them in, we're gonna have a trial. In juvenile court, the kid has a right to deny the things brought against them, but it will not be in front of a jury if we have a trial. It's gonna be in front of the judge. A second thing you're going to notice, and this is a part of that whole, we're trying to do this for the kid, is throughout the course of the proceedings, from basically the beginning all the way through, you are going to be expected and ordered to do a number of assessments, okay? And we have all kinds of acronyms we use for them. And if you're in my court and we start using the acronyms, just say, Judge, what are you talking about? Because I don't blame you. But you'll hear things such as PSRA and PRA and SBRA and NOJOS and on and on and on and on. And they're all really just boiled down to professionals doing assessments with the kid and with the parents to figure out what is best, okay? They're important to do. They give great information to the court and they give great information to probation about how to proceed, and really to everybody. They can become a bit and I will admit this, sometimes I feel like some of the assessments don't really reach the depth that we need to with regards to what's going on in this for this kid. Sometimes they seem a bit surface and they just feel like everyone is just like the past one. But I know that the people doing them do a lot and put a lot into them, and it gives a lot of good information for everybody. All right, let's say that you get to court the first time. You can do a couple of things. Sometimes you'll reach a resolution. It's commonly called a plea agreement. Sometimes the kid will say, no, I didn't do this, we'll set it for trial. If we do a plea agreement, I'll talk to the kid a little while. I'll ask him if this is in fact what he wants to do. I'll make sure the kid understands that, you know, what the possible consequences of saying that, yes, I did this are. And then normally I'll accept the plea agreement. The kid will say, yeah, Judge, I was out with my buddies, you know, I'm a good kid, but, you know, we went and we smashed some stop signs or whatever they did. And I'll say, okay, well, you know, tell me what you did. And I make them tell me that's what I did, Judge. I was involved in that. If the kid says, no, you guys brought this stuff against me and I didn't do it, we'll just set it for a trial. And at that point, the prosecutor actually has to provide the witnesses, give the evidence, and prove that the kid did it beyond a reasonable doubt, okay? But let's say we get to the point that the kid either said, yes, I did it, or we went through a trial and it's found beyond a reasonable doubt that the kid's, you know, committed whatever offense that's been alleged. All right, at that point, we complete our assessments. If it's a sex offense, they complete what's called the sexual behavior risk assessment. If it's a normal offense, it might be a pre-screen risk assessment or a protective risk assessment. I'm just saying this not for you to take notes. I'm saying this to just don't be scared when you start hearing this stuff, because it's going to be said, and don't freak out. It's just basically saying, Judge, we want more time to do an assessment to figure out what's going on. I'll normally give them time to do the assessments. We are encouraged, obviously, to get that information before the judge just goes off the rails and orders whatever he feels is right. So we try to get all the good information we can. You've admitted you did the thing. Parents are with the kid. Parents are like, oh, why'd you do this? But you did it. Okay, we'll deal with it. Or sometimes parents are like, Judge, help me. I got a problem here. This kid's out of control. Take this kid, put him away. You know, I'm done with him. Can't handle him anymore. He never does anything I ask. And I'm like, okay, I understand your frustration. Give us a minute. Let's figure out what's going on and see if we can help you out. I continue the hearing a couple of weeks. Probation does their assessments. Sometimes it's private providers doing the assessments. We get the information back. And then probation completes a report. They send me the report essentially saying, this is the kid, this is the family, this is the history, and this is what we think you should do. You know, this kid falls into low risk, high risk, moderate risk. These are the risk areas we believe that you should be, and here's where the judge has the option to do various things. Upon what we call disposition, it's like sentencing. In sentencing, the judge can, in the juvenile case, do a number of things. And I'll just kind of go through them just briefly. Number one, put a kid on probation. There's 2 levels of probation: intake, formal. Intake's a little more, hey, give me a call, how you doing? Formal's a little more, hey, well, I'm going to come down to your house and search your room. And so that there's a couple of levels of probation. Second, I can put a kid in detention, but I can only put a kid in detention for up to 30 days, okay? So 30 days by statute for each incident is the maximum I can put a kid in detention. Third, I can order evaluations, I can order treatment. I can order, if they qualify for this, meaning they committed an aggravated offense or there's a number of offenses that the kid has committed in the past, I can actually order the kid taken out of the custody of the parents and placed in the custody of Juvenile Justice Services. A state agency, I say, JJS, here you go. Juvenile Justice Services at that point has the temporary custody of the kid, and they will look for a community-based program to put the kid in, okay? They'll find the program they feel is best for the kid, put them in that program to try to address this kid's needs. The judge then has to review the program to make sure that this program actually is the right one for the kid. Historically, there has been some issues with regards to programs having way too many kids in and only one counselor, or, you know, just things that just perhaps some programs weren't exactly run the way we would expect them to be run. And so it does come back to court, and the judge does a thorough, you know, analysis of the information with regards to the program, what program is being created for this kid. And then the judge makes a determination that, yeah, okay, this looks like the right place for you, or nah, you guys missed the mark here. You know, you got this kid in this, you know, really quite secure program. That's not where this kid should be. And so the judge does have some judicial oversight with regards to those type programs. The last thing that the court can do if things have just gone off the rails and we have not been successful, or the crime is extremely aggravated, is the court can place the kid in Juvenile Justice Services for secure detention. And that would be considered kind of a prison for juveniles. Obviously, they try not to run it like Rikers Island, but it is a more secure facility. The kids still get an education, they still have programs, but it is more secure. There isn't as many freedoms. They can't go out into the community, things such as that. These programs, if a kid gets into the the community-based programs, we actually have it in which we try to get them in and out fairly quickly. 3 months in the life of a kid or a teenager is a long time. It might not seem much to us as adults, but that's a long time in the life of a kid. And so we really try to get them in, get them stabilized, get them some skills, and as quickly and safely as possible, get them back in the home, okay? Does it work that way? No, not that great all the time. Usually the kid gets down there and there's a bit of a rebelliousness. It's not terribly unusual for the kid to make a run for it the first month they're down there. And so we usually have to get them over the anxiety of being there, get them acclimated to the place, and then we can really start chipping away at some of those issues that led to the kid being in the system. And also, if this is a sex offense, the honest truth is that the therapy and the treatment that is provided for individuals that get into the system under sex offenses, generally that treatment and therapy is they proceed cautiously and slowly, and they really they want to make sure that they're hitting on all the possible problem areas that have led to this. And so we can have kids down there on sex offenses for a long time, a number of months into years. And a lot of it depends on how the kid responds to the treatment as well. So during the course of the time that the kid is either placed on probation or in juvenile justice services, every 30, 60, 90 days, everybody comes back to court. And essentially they tell the judge, here's where we're at, here's where we still need to work on things, and here's what we've done well. And the court looks at it, and what they're trying to do is basically have a judge follow the cases to make sure we're not dragging this stuff out beyond the necessary, that we're getting done what we need to do. And so you will be brought back in on reviews periodically to see that we're doing what we need to do. It's probably a good thing, I think, not because I'm the judge and like that power, but just because sometimes these the programs, the community-based programs, need a little bit of a kick in the pants and say, look, this is the exact same report you gave me 60, 90 days ago. If you guys haven't done anything in the last 60 to 90 days, then we're going to look at a different path here. And just sometimes a judge kind of given that pressure gets things moving again for everybody. Last thing, on very aggravated offenses that come into juvenile court, aggravated homicide, those sort of things, aggravated burglary, aggravated homicide, aggravated assault, certain things that are extremely menacing to society can begin in the juvenile court, and then the state can actually petition them to be transitioned to the adult court. And so normally they will start in juvenile court. We'll do an assessment about what type of case this is, what would be not only normally the best interest of the kid in that case, but then we get into an analysis about what's in the best interest for the community as well. And we go through a process in which the case can be transferred to district court. All right. Happy to answer any questions on the criminal side of the system. If you have any, feel free. I know I kind of get talking fast at times. I apologize for that. My mind gets racing. I think of all these things I'd like to tell you guys, but I know our time's limited. All right, that's kids behaving badly. Let's transition just briefly into parents behaving badly. That's the other prong of the juvenile justice system. On this one, usually there will be a referral to the Division of Child Family Services or law enforcement. It can be law enforcement. Say the law enforcement gets information that, hey, there's a drug house on West Main or something like that. Go down there, they get a warrant, they go in there, there's kids and a bunch of parents in there that have a meth lab, something like that. At that point, either through a referral to DCFS, Division of Child Family Services, or law enforcement, if there's an allegation of neglect or abuse of a child, there's an investigation done by the division. If they find that they believe there's been neglect or abuse of a child, then there can be a petition filed in juvenile court for the court to take over jurisdiction of the case and essentially bring the parents in, go through the process. If they are found to have neglected or abused their child, then it can be physical abuse, it can be emotional abuse, it can be emotional neglect, it can be physical neglect, or obviously not physical neglect, but neglect of the child. They're asking the court to actually take jurisdiction and order the, number one, oversee the safety of the children. Okay, that becomes primary on those sort of cases that end up in the court. Overseeing the safety of the children. Second is, if it is found to be appropriate, oversee either, and I should have said this earlier, but upon one of these petitions being filed of neglect or abuse against a parent, that petition can be one of two things. It can be a petition in which the kids have actually been removed immediately from the parents. And if that happens, then that comes into court really quickly, within a couple of days. If kids get taken away from parents, we get into court and we start talking about things. And the court has to decide whether, okay, it was right to remove those kids because of safety concerns, or nah, you guys jumped the gun. You know, I think the kids can be back with the parents, but we are going to work on things. So if the kids are taken out of the home, then, the kids can remain in the home but have been subject to neglect or abuse. Either one of those things, kids in the home or out of the home, can get into court, and the state, Division of Child Family Services, through the Attorney General's office, is saying, Judge, this has reached the point that you guys need to oversee this. You need to watch for the safety of the kids, and we need to decide what's in the best interest, whether it's in the best interest to keep these kids in the home, get these kids back to the home, or consider at times not reunifying the kids with the parents. Okay, that does occur occasionally. So if you ever find yourself in a situation in which DCFS is doing an investigation, they're looking into neglect, abuse, they're in coordination with the State Attorney General's office as to whether it should be filed in court. Many times parents actually, upon being investigated, can choose to work voluntarily with the state, okay? They can say, look, we need help here. We're not trying to avoid you. We need help with these kids. These kids are killing us. We're not trying to be neglectful. We're not trying to be abusive. I've got a kid that's out of control, or something like that, you know? Or sometimes it's just parents haven't been able to provide the necessities for kids. Or you could have a parent with mental health issues, or in which the parent just struggles, you know, with their day-to-day existence and can't really keep up with the kids. But they may say, can you help me? And a lot of times the state is willing to enter into an agreement for the parents to voluntarily work with them, provide services from the community, coordinate services from the community to help the family. They do that without ever coming into court and having to go through that whole anxiety of the court process. But if you find yourself in court, you'll get what's called a petition. You'll read the petition and you'll hate it because it basically outlines in bullet points everything that the Division of Child Family Services or law enforcement or the Attorney General's office says that is bad about you as a parent. And they're neglectful in this way, they're abusive in this way, they have a history of this, and on and on and on and on. And it's not fun, and it's horrible for parents to go through that, and it's really tough to read in those documents. And I try my hardest when parents come in to let them know, take a deep breath, we're going to work through this together, okay? We're going to get through this. Okay, parents have the right to attorneys. I normally appoint state-appointed attorneys to represent them so the parents don't have to pay for their own attorney. Most of the parents that end up in court, to be honest with you, are indigent and qualify to have attorneys appointed to represent them. And I lean on that side anyway. It's such a confusing system and so hard anyway, they've got to have an attorney. And making the family go out and hire private counsel just puts them further behind. And so I try to get attorneys appointed to them as quickly as possible. Another thing, and it's just my general philosophy, if we can fix a kid and a family and provide services to them, either a criminal delinquency kid or a child welfare neglect or abuse kid, if we can do the services in the home, that's where I'm going to do it. It sometimes is necessary to take the kid out of the home, but providing services to the family while the kid is able to stay in the home you have a much greater chance to effectuate actual meaningful change that this family can take into the future. Okay, back to the child welfare stuff. Parents read the petition, they might say none of this is true, but it's absolutely not true. None of this is true, or they might agree, I don't know. But normally what I do is, and I should have indicated who the parties are when you come on one of those cases, but there's going to be a lot of people. There's going to be a representative from the Division of Child Family Services. There's going to be an attorney from the Attorney General's office. There's going to be an attorney called a guardian ad litem that actually represents the kids. So there's going to be normally two attorneys, one that represents the mother, one that represents the father. Or sometimes you'll have a situation in which it's one mother and a couple of 2 or 3 fathers. So each one will get an attorney. You're also going to have, normally that's about what you get in those cases. Sometimes there's some special visitors and so on and so forth. You'll come into court. A lot of times what we'll do once the attorneys are appointed is set the matter for what's called a mediation. Mediation, just basically a time that everybody can get together, have a discussion, and decide how to proceed. Okay? Decide whether we can come to an agreement about this. In our district here, I'm really proud of what happens because a lot of times that's the first time that the parents who really are defensive, coming into the system, being accused of all these horrible things, they're defensive. They actually get a chance to sit down with everybody, and we've really tried to create a culture of not us versus them. Insofar as us versus them, when I'm talking Division of Child Family Services and the family, and not make it real accusatory, but make it, we're all in this together and we want to do whatever we can to help the family together and give you the services that we can provide you to get you moving forward. Once they do that, and I try to incorporate that into everything I do in court and try to thaw everybody's polarization on things, begin to get a common interest with regards to what needs to happen. A lot of times they come into an agreement, they come back to court, they say, Judge, we see everything the same on this. This is how we want to proceed. The parents at that point have to agree there's been neglect or abuse, or we have a trial. If there's found to have been neglect or abuse, the parent admits it, or we have a trial. At that point, really what I do is I order normally 100% of the time until it just doesn't work anymore, that the division is to provide community-based services to the family. And they're really the hub for getting all of the services that are out there in the community into what they believe will be the best for this family, okay? In-home services, drug and alcohol, mental health, families first, just anger management, domestic violence, any community-based program that's out there that can help this family. We use the court and the division as a hub to get those services to the family. I will order that the division provide those services to the family. And at that point, we begin the process of trying to fix whatever problems led to the neglect or abuse that got us here. If the kids are taken out of the home, just quickly, we got a year to get everything back together. We got 1 year from the kids being taken out of the home to get the kids back in the home, and for the court to say, okay, we did it. We got everybody back in the home, we're doing well. If the parents just can't get on top of things at any point during that, then one of the parties can say, Judge, this isn't working, we're not gonna make it. The parents aren't responding, we can't get these kids back in the home safely. There can be a petition to terminate the parents' rights. And then we would go through the process in the trial towards the termination of rights, okay? I'm gonna take a breath. I know I've been about 45 minutes. I don't know how long these normally go, but I want to give everybody a chance. I don't know, Valeria or anybody that has anything they'd like to add, discuss, or ask.
We usually go about 45 minutes to an hour. We've had some comments along the way. I'll read them really quickly, and then I've got a question for you.
Yeah, go ahead.
Yeah, let's see, let me read these really quick. Emily shared that as a youth, she participated in youth court, which was one step below juvenile court. She says the jury is your peers. They typically assign service hours, and she thinks it's a great option when available for less serious offenses. I think that would work. And you're signed up peer mentor. Let's see, Shirley. Oh, when you were talking about how many people are in court, Shirley reminded us that they're there to help the family. Having been to court a number of times myself for different things, just the physical act of going into court makes me nervous. So knowing that people are there to help would help.
It's actually funny you say that, because as everybody knows, we've been doing everything on the web. Not everything. I do, 10% of my hearings in person. But it's really interesting you say that, because we do in these WebEx hearings. And many, many times I'll have a kid or a parent that's really full of bravado. Kind of, you can sense a little bit of tension, a little bit of anxiety on their part, and, a little bit of just, you guys can kind of, whatever, you guys, I'm not dealing with you guys, or I'm going to go in there and tune you up, or whatever they kind of the impression they give, or what they say sometimes, right down to FU, which I get several of those,
Oh, boy.
But you know what? Even the most hardened, jaded individual, once they go through the process of actually getting up, getting dressed, parking the car, going through the security downstairs, and having to come through the courtroom doors, and all of a sudden sit there and say, oh, it really is a truth serum in some ways, and it really does change people's attitudes with regards to what they're doing at that point in time. The physical act of being in court is important. It really is, because it really sets people in a mindset of, okay, let's see where we're at here. and let's see, I want them to know they have their rights. They have the right to dispute everything that's going on and every allegation against them. But also at the same time, hey, it might be a little bit of a wake-up call to have to get up and come into court and sit down. And all of a sudden you're looking at a bailiff that's 240 pounds of muscle, and just the attorneys who all of a sudden, you didn't respect at all when you're on the phone with them, but you get in there and you're all of a sudden like, wow, this attorney might be my only, lifeline to actually surviving this experience. And also just sitting there looking at the judge, and all of a sudden you're looking at a judge who looks like he's had a bad day and could order anything at this point, it feels like,
Yeah.
So yeah, it is an experience to walk into court. It's something that is needed. That doesn't mean that I'm against WebEx. I just think that if we ever get back to some sort of normal, we need to kind of balance using the both. Agreed.
The question I had, and if somebody else has a question, go ahead and put it in the chat or raise your hand, has to do with the after effects. You've either as a juvenile or even as a young adult, maybe 18, barely still in high school, and you've committed a crime. How do you go about expunging your record later? I mean, I know a lot of kids make dumb mistakes. Like I said, I had 4 daughters, and some of them made more mistakes than others. I was not that kid. The only time I ended up in court as a child was like over a traffic ticket. And anyway, but sometimes how do they go about taking care of
great
dumb little
question.
mistakes? Yeah.
Actually, I have some experience in that, because to be honest with you, I had to expunge my own record. And so I do know how to do that. Not nothing too much, to be honest with you, I don't know if I ever expunged anything or not. But hey, we're trying to make it easier and easier. Really, we're trying within the system to make it extremely easy. The non-judicial stuff, we're getting to the point where anything non-judicial should just be sealed up. Okay. Excuse me. Once the kid becomes qualified, which is generally over the age of 18 and off probation. All right. And if you have a juvenile record, really it's a matter of getting qualified, which once again is off probation for generally we look at a year, and don't owe any obligations to any other courts, don't have any other courts going on. And it's usually after you've been off probation and you're 18 plus a year. So at that point, you can come back, petition the court. There's actually, I think, online forms, and the clerks at the court can really help you do that. You really don't have to have an attorney to go through that process.
Okay.
They can make it easier, but if you prefer not to, and are good at just kind of being patient and understanding that,
Okay.
okay, I just fill out
Is
this
there,
form. Go
is,
ahead.
is there a point of no return where you have too many things on your record to have it expunged?
I'll tell you what, not that I'm aware of statutorily, okay? And I would really be willing to consider expunging anything myself that was committed by a juvenile. Now we have had some, individuals that have come through the courts where in which perhaps if they, commit homicide or something like that, I mean, they're
Right.
going to have to, exhibit a higher level of rehabilitation than I might expect out of a lot of the other meat and potato stuff that we see every day. But I would certainly consider somebody coming to me at any point and asking for that expungement or the sealing of the records.
Okay.
Yeah. It's really, we're trying to get it where it's quite easy. I know that nothing in the courts is easy, so I don't want to use that word too much, but we want to make it as easy as possible for everybody. And I can almost tell you, if you get in front of me, you have a really good chance to get it expunged.
Okay.
I believe in expunging those things.
Yep. Somebody threw in a comment, was Shirley. She said, how can we help youth know that their choices have long-term impacts? I think that was sparked by my question about expunging your record.
Wow. Kids are not, and I'm not the expert here. I don't want to pretend like I'm the educated expert with regards to children. But I've been through a lot, and I've been through a lot of courses, and my job obviously has allowed me to learn a lot and be educated from people. Kids are not creatures that generally think of long-term consequences. And I'm going to tell you guys right now, if you figured out the magic potion to doing so, I would really want you to email me what that is. Each kid is obviously an individual, and some are much more focused, goal-oriented than others, looking to their future and their education and staying out of trouble. Some just are scared and don't want to be in trouble. They just don't want to hear from mom or dad. But if you have a kid that we just can't quite reach to get them to see the consequences, we do have programs within probation that addresses what we call consequential thinking, okay? And it's one of the actual things that we put almost every kid that ends up in the system, we put them through the consequential thinking course.
Okay.
Okay. Does it work? Probably not. But maybe at some point that kid will take some of those skills they learned and be able to apply it. So I'm not going to say probably not. I'm just going to say that we probably don't get the immediate results that we would like to see. And it's a great course, and it's not unusual for our kids to take it many times.
Oh, many times.
Well, some of them come back for many different things, so they get to start over. They get a refresher.
We had another question. Is that course available to the public anywhere?
You know what I would do there, if you're ever having any trouble with regards to raising your kids, or you're involved in a community program that is working with kids, or a group of kids, some of the things that may be available would be provided through Juvenile Justice Services. And I know that they do, and they do a number of things through public outreach. And let me just pull this up real quick.
Yeah.
But they do school-based programs. They do home-based programs. They do day skills intervention. They have a number of these same type. If it's not exactly consequential thinking, it'll be the same type of course. And they actually have a number of programs that are designed to work with people and kids. Say kids are having trouble in schools. Juvenile Justice Services works with the schools all the time, and they get information that a kid's struggling, and they'll try to come up with services to provide that kid in the community. And so if you're ever having any issue with regards to a kid and wonder what's out there, Contact number one, there should be a liaison in the schools. The schools, you should say, look, I'm struggling with this kid. I'm having a hard time getting to school. I'm having a hard time, no interest in class. I think they're using, I have reason to believe they're using drugs or whatever else, Then reach out to the schools, or you can just get online and contact Juvenile Justice Services in the community you're at. It's a state-run program, and they have a number of professionals and contracts. And I can't speak for if they have the exact same services at all areas of the state. Obviously, sometimes in the rural areas, they may not have as much as they do, for instance, in the urban areas with regards to services to provide. But they're a great resource to use without actually going through the mess of, well, you have to go to court.
Okay.
So if you feel like you're heading down that path, reach out to the schools, because the schools, everybody doesn't know this, but the schools, probation, the courts, juvenile justice services, and whoever else, there's a bunch, are in coordination and actually have coordination meetings within our district all the time. And they're sharing information and they're sharing emails. And it's not to tattle about a kid, oh, this kid's being a jerk. It's really just, hey, these kids are struggling, this family's struggling. Let's see if they need help. So it can really be helpful to give families some resources without going through having to come and do it under the purview of the court.
Okay.
But we're always here. If you end up
That's
here,
true. You're not going anywhere anytime soon.
we're not going anywhere.
Yeah.
So
Well, asking that question and getting that information from you just put more work on my plate. So
well, you're welcome. So
thanks a lot.
hey, if you do really good, I won't see as much work on my plate. So
Well, wouldn't that be that? And that is our goal. At My Discovery Destination, we put out adventures for families that are geared to building resilience in youth and strengthening those families, putting those protective factors in place so that our kids are not at risk for any errant behavior, including breaking the law. So that is the plan.
It is true. And this is Bryan talking. Sometimes we just gotta be there for these kids. And these are the ones, I see the ones that, they're the ones that are struggling maybe more than most. They're the ones that end up in court.
Yeah.
But even with those kids, you know what? First of all, don't expect perfection. Let them know you're there for them. We're really there for them. And really sometimes, I can't tell you how many times we're just trying to be there as bumpers for them in life so they don't go too far into the gutter. And we're trying to keep them, and eventually, you know what? They mature.
Yes.
A lot of these kids just grow up. And you'll have kids that you're like, we're never going to make it. We're never going to make it. And if we can just avoid the really bad stuff for long enough, they tend to grow up.
Yeah.
And you know what? Me as a judge, I pat myself on the back and say, man, I gave good orders there. And it had nothing to do with me. I did nothing, but we just tried to be there for the kid to make sure we didn't go too far off the rails.
Yeah. Well, I love the bowling analogy you used about the bumpers in the gutters.
No, and that's kind of, I don't know. I don't know what all the other judges and courts do, but I really try not to look at most of these things as being punitive in nature. I really try to structure my orders insofar as whether it's a fine or community service, which I think the legislature is trying to do away with fines in juvenile court, which is somewhat understandable, even though I do have some kids, to be honest with you, have a job and would rather pay the small fine than go do the community service. But I'll give community service, and let's say I have a kid that's using drugs. That's an easy one. And not going to school. And I'll bring them in and say, look, here's the thing I'm going to do for you, my man. I'm going to put you on probation, and I'm going to order you to do all these hours of community service, and I'm going to order you drug and alcohol treatment. But I'll tell you what I'll do. If you just go to school for me, don't disrupt, participate, and attend, you know what? Every one of those hours of community service, I'm going to give you credit for it. And so I'm just trying to get them in the, make it a habit to do something positive.
Mhm.
I'm not after making that kid go down on the highway and pick up garbage. I would much rather try to fashion a sentence where in which, okay, here's the deal, my man. You might end up in a little bit of trouble, but I'm giving you a path out of here. And it's really just do a few things. Give me some clean drug tests. If I can get a kid that's been using for quite a while and I actually get them or they're giving me clean drug tests, I mean, sometimes I feel like throwing a party for them. I mean, but then I'm afraid they'd be back where they were. So, but so I try to make it that way where in which I'm not trying to expect too much from the kids. They do not need to get to the point that they're perfect in life, but just get them a few skills, get them on the right step, get them some resources, get them understanding they can do good things. Most kids that end up in this system have been told forever that they're, an outlier on society, running with their own crowd, a bad influence. A lot of the, unfortunately, there's a perception that a lot of the Hispanic boys in my community are running in gangs, and even law enforcement approaches a lot of the kids that way. Oh, they're in a gang, they're in a gang, they're in a gang. I get the kid into court and I'm like, this kid ain't in a gang. His last name's Gomez. That doesn't mean he's in a gang. But sometimes these kids have been pigeonholed into that for so long. Hell, it's what they start doing. We've actually,
yes.
We've created their reality for them.
Yeah.
And so if we can somehow get them in a situation where in which, man, all of a sudden I've got a judge or I've got probation saying, you're doing good. If I can do that, maybe that'll give them some foothold to build on.
Yeah.
Maybe
Helping them
not.
see their own value. Absolutely. Yeah. Well, thank you. We have taken at least an hour of your time. We know you're busy and we really appreciate you being here. I almost hesitate to ask if anybody's got any quick questions because we're a little bit over time. Does anybody have a question that they just have to have answered right now?
Yeah, if you do, go ahead. If not, you can always email me, or I apologize if I rambled, but
It's been wonderful information. We loved this. Okay. So how do you feel about sharing your email address with us?
Yeah, I can do that.
Okay.
I can do that. It's B Galloway. Just B the letter and then Galloway at utcourts.gov.
utcourts.gov. Oh,
Yeah.
we got it in there. Okay.
And
Thank
then,
you so much.
They screen it pretty good. So if somebody
Okay.
cuts you off, just say the judge said I could email. So
Okay. Okay.
all right.
We have permission. Everybody, we've got
You
permission.
have permission, sure.
Yeah. Thank you so much, Judge Galloway. Valeria,
thank you.
anything do you want to add at the end?
No, I just wanted to say that I put my contact information in the chat. So if anybody to get in contact, they can reach out to me. I'm trying to put together a newsletter with court updates. So if anybody wants to be updated on the programs that we have with the courts, they can email me and I can get them added on the list.
Perfect. When I download the recording, I will get the chat and I will add that information to the post with the replay later on today, early tomorrow.
Thanks so much, Judge. And thanks so much, Megan and Shirley.
Thank you, everybody. We'll see you next week on the 7th at 1 o'clock. And then take note that the 14th is Valentine's Day, so we're taking off. But we'll see you next week, February 7th at 1 o'clock. Thank you.
Bye.
Bye-bye.